people would perhaps pick that up and just make the exchange at some point. Our next and final speaker, we have the privilege of having really one of Ontario's most preeminent litigators. David Bristow is, of course, Queen's Counsel. He's the co-author of the standard book on construction and mechanics liens, and among many other honors, he was the recipient of the Canadian Bar Association Ontario Distinguished Service Award in 1996. I could go on, but I don't think that would. I don't think I can cover everything. So perhaps I could just ask Mr. Bristow if he would speak to us and wrap up everything we've learned so far today.
Thanks, James. I don't know if I'll be wrapping up everything that they said today. I read all the papers. I came in just to hear withdrawing the offer in the washroom, and I didn't quite catch the gist of that. But while my partner, Karen Groulx, was being sick, I read all the papers. I just want you to remember or stay with me on a couple of things. There is a quote on the first page of the paper, right on the start, and then I'm going to leave you at 3:30 with another quote to end the thing up. If you don't read any of the rest of it, that's fine. The one on the front page is a judge out west, a master out west, acting out because the issues and the theme of the case were not succinctly put in front of him. It wandered. It went all over the place and finally exploded. You're going to find that the judges aren't these even-tempered folks that we've been seeing in the past. They're going to be speaking out. If you don't get the theme, and if you don't get the issues in front of them fast. So he said, a lawsuit between contractor and owner, reasonable parameters to the issue, has been turned into a vortex black hole, likely created by someone with a highly overworked imagination, the lawyers. Everyone in the vicinity is being sucked into the black hole. All right, what he's saying is, look, will you get to the issues and get to the point? And as a matter of fact, he got so mad that he said, you can't even plead half the issues you're in front of me on. I won't allow it. What I want to talk to you about first is, and my topic is at trial and in the preparation for trial, what is the theory? Stick to the theory. But what's happened to the legal system in the last 10 years? In my view, in the last 10 years, the whole system has changed more than the last 100 years. We are into the electronic age, and we're never ever going back to where we were. The administration of justice is going to be run electronically, as are all of our law firms, if they are not being run that way now. The libraries are going to disappear. We're going to have, and we have in our firm, a whole bunch of folks with great big eyes and big ears and little wee legs watching these computers all day long in rooms that have no windows. And when I say to the nerds, as I call them, I would like you to get me every case on wrongful dismissal with such and such a lawyer in it and a judge in it. 30 seconds later, the nerd comes back. It doesn't run back because of the small legs, but walks back and hands me the answer. 10 years ago, you used to have to read things out of a book. All right. Now, the world's getting compressed. The legal profession is getting compressed, and the judges are getting compressed. I said in the paper that the thinking is now the 4x3 mentality. Now what's that? That's the dimension of your television set. And the attention span of most of your clients, and increasingly a lot of your judges, is 3 minutes between commercials. Now this may be a bit crass that I'm talking to you about it this way, but the judges are no different than everybody else in the community. They're compressing everything. And you've got to be able now to pitch your theme, your theory, your issues in an entirely different way than we used to do it. We would have this great preparation, these huge speeches and everything else, and wander and ramble. I won't let you do that now. More and more, the judges are going to cut it down and say, get to the point. What's your theory? Give it to me in one line. The other problem with the legal system, it can't go on the way it is because we've got rivals. We've got the ADR chambers. We've got the private court. We've got all kinds of mediators and arbitrators drawing cases out of the system. So the judges, the system has to compete. And it's got to get its act together too. And you'll see in the paper that this whole new slogan, JDR, is now coming forward. And it's rivaling ADR. Judicial dispute resolution, they're all getting on the bandwagon, the compression. They're getting on the mandatory mediations. They're getting on a pre-trial every 35 minutes, it seems. They're going to make deals. They want it quick and they want it fast. They are going to, at least I predict they're going to do, they're going to cut down the time for examinations for discovery. They're just going to cut you off. They're cutting you off in the Court of Appeal. They're going to do it everywhere. They want it fast so that when you're preparing for trial, and that's the subject that I'm going to get to when I stop this long-winded tirade, then you gotta give it to them quick. Now, Justice Laskin said, he wrote a wonderful paper, and it was entitled, "Forget the Wind-Up and Make the Pitch." Remember that. Court of Appeal judge, one of the best. Here he's writing with a title. Don't get into all the preamble and all the mumbo-jumbo and the legalese and the rest of it. Throw the ball. Make the pitch. Or get out of my court. I can hardly tell him to get out of the Court of Appeal, but that is now the judicial thinking, streamlining everything. You're going to be under extreme pressure to give the case in simple sound bites. You're not going to be able, I don't think, to carry on in the old fashion. All right, let's get down to the paper that I'm supposed to give, the theory at trial. The preparation for the trial has been given by others. Preparation, of course, starts when you get the file in. You're thinking about what you're going to do from the day the file comes in. But in the preparation, you review first, I do anyway, the pretrial memorandum. Hopefully, your opening and preparation for the trial is going to follow the pretrial memorandum. Either that or a junior's done it and you've got another theory. But pick that up and you can usually start setting up your opening and the way you're going to play the trial from the pretrial memorandum. You review your opponents too to say, okay, what's the theory of her case or his case? And how do I tailor then my opening to blunt that? Sometimes it's very difficult when you read the opponent's pretrial memorandum to figure out what the theory is at all. That may be an advantage, it may be a disadvantage to you. Your visual aids, you get them all together. Your photographs, your models, all of that material that you want to put together with an opening theme at the trial. The names of your witnesses, the key points. And if you look at Solomon's lecture, he has this wonderful layout, the chronology with the date, the event, reference, issues, the whole thing. Wonderful kind of a thing to follow when you're getting your case and your opening ready for trial. That's the kind of thing we use. We put the document beside it. We put what somebody might have said on the examination for discovery. All of that goes into preparing your theme, distilling it into the theme of what you're going to pitch to the judge. Your experts, absolutely critical to get all of their evidence in line, in chronology, and where you're going to set them in your theme. Where you're going to set them in your issues. Now, around this time, and it may be a little later, we go to the nerds again and say, okay, fine, go to the machine, here's expert Y, plug his name in, here's the issue, plug his name in, find out if he's ever given evidence before, ever given a paper before, or anything else, and does the expert's testimony fall in line with your client's theme? If he waddles back, or she waddles back, and says, here's one, yep, terrific, terrific. If it's dead opposite, not so terrific. And then you say, hey, we're doing pretty good, so why don't we check the judge's name, if you know the judge. Sometimes the judge just comes out of the chute and she or he is there. But if you know ahead of time, run them through the computer. Back they come again. Hey, decided 3 cases. Your theme, they accepted. Terrific. That's when you get a call from the other side, because the other people have got computers too, and they're running off the same stuff you're running off. So they say, hey, I think I'll up my offer a little bit. I don't really know why, but it's not worth it going to trial with all this expense. Run the computers through, see if anyone has picked up your theme, especially the trial judge, the one you're going to have. Because if the trial judge isn't on your wavelength and you know it beforehand, maybe you ought to settle or change the theme. You're going to prepare your client's opening statement. In my view, the opening statement is probably the most important little item in the whole of the trial. It's absolutely essential to give an overview with the key issues and your client's theory. If there are key pieces of evidence or documents, I include them in the opening. We used to just get up and we'd say, okay, this is the case, so-and-so, so-and-so, and so-and-so, and these are a few of the facts, and off we go. Now the opening's an art, because in most cases, the trial judge is handed up an opening book. It's got the opening in it, and then it's got nice little tabs on it, and it's got the key shots for your case. Now, more and more judges are bringing laptops into court. Remember that. Have a disk ready of your opening, and you will know, if you check around, which judge is going to walk in with a laptop and sit there and say, does anyone have a disk of the openings? Oh yeah, we got one. Now, that probably is the only document, piece, that the judge is going to carry around through the whole trial. She or he takes the laptop home, pops it open at night, and there's your theory. They don't want to carry around a great big bag of documents and evidence and everything else. This is the way the world's going. Pretty soon, another 5-10 years, it'll be just in the rules. You just come up with it, you hand it to them, and if you don't, you're in trouble. Go to the moral high ground. Judges are less and less inclined to the law and more inclined to the morality of cases. At least that's just my opinion anyway, having lost a lot of immoral cases. They are tending to say, what is the right? And saying, well, justice is what's right, not maybe what's all the law. Find the moral high ground in your theme if you can. If you don't have one, find the highest legal ground to win. But if you have anything moral at all, push that out. Also, absolutely essential, when you get your opening ready, give it to your client. Review it with your client. Review it with the key witnesses. Review it with all the witnesses. If your client doesn't know the game plan, know the theory of your case, what's going to happen, she or he is likely to say the wrong thing when asked the questions. Also the witnesses. Important also to get it to your experts. It's amazing how many experts are called to trial, don't know what the issues are. Haven't got a clue what the issues are. And then when the opposing lawyer asks them something, they say, oh yeah, that sounds great. Get it over to just about everybody on your side. Because really what you're doing is conducting a play, a stage play. Think of the trial, which has a prologue, a lot of acts in the middle, and an epilogue, the end. It's got a cast of characters, got a playbill. You are trying to please an audience of one. You've got to communicate with that audience of one. That audience gives you a standing O, you win. If that audience has thumbs down, you lose. Your opening is absolutely essential. Your opening's like your playbill. The judge reads it and says, oh, gee, I like this story. I like this. I'm going to get excited about this. I really do like it. Or, poof, this is the dullest stuff I've ever seen. I'm turning off. Okay, I've told you about filing the plaintiff's opening, the memo. I always file or try to file a cast of characters, as I call it, witnesses on both sides with their positions and everything else, and work the cast of characters into the opening to say, well, so-and-so was in and did this and that, and you're going to remember or see so-and-so because that's key. If you're opening for the defense, I always like to open right after the plaintiff opens, not when the defense is called, but to get right up after the plaintiff's through, do the same thing the plaintiff has done. If the plaintiff has given a book or a disc, have your book or your disc ready. And do the same thing as I've said for the plaintiffs. If you're in a jury trial, you got to ask for an order that you can do that. The rule's there on page 6, but they always give it to you. There's no reason for not. Okay, knowing the judge. I've covered knowing the judge. This is something that's overlooked by many counsel. Before we had all the computers and the instant ability to get information, we just used to go up and down the halls asking who's that judge, what she or he do, what's the track record, kind of hit and miss, phone other lawyers, maybe even other judges, and say, well, what's happening? Now you've got this great internet, you've got everything going for you. And if you don't use it at your docket rates, you should have folks that can do it better than you and faster than you at less in the docket rate. Okay, let's turn now then to the direct examination. I always like to still keep the 3x4 image in my mind of trying to get to the point with a witness and get the best shots in. If you got documents, stress them and use them. That is real good ones. Don't bore everybody to death with 800 documents you don't need. But if you have, say, a letter that says, yes, I accept your offer of $8 million, signed so-and-so, use it and repeat it. You'll probably have that letter in your opening statement, tab C, D, or E. Repeat your theme with your best documents. And as I say, a good document is almost always better than good oral testimony. I always like to try to leave out extraneous evidence. It's difficult, however, to keep a rein on your client who wants to tell the story in their own words. I always say, now that's wrong. I say, you tell the story in my own words. Keep the rein, try to keep the rein on the witness, to keep on the theory, on the theme. If you've got bad evidence that is going to come out by the other side, confess and avoid. I always try to do that. Ottawa, we'll see you later. Sorry. That's my friend from Ottawa leaving, which, there's not too many folks here left this afternoon. I was in Vancouver a couple of years ago, same thing at the UBC giving a lecture. You should see those folks. They come with their tennis rackets, tennis shorts, everything else. And one by one they all started to leave, and there was one fellow down here in the front row, and I finished. And I went to him, and after I was finished, and said, well, geez, thank you very much for staying. And he said, don't thank me, I'm the next speaker. In any event, Ottawa's gone, and I've lost my place here, keeping a rein on witnesses. Let's get to the cross-examination. You will have your client's list of issues and documents all set up with something like the Solomon chronology. You're going to try to keep on the theme to get from the opposing witnesses your theme, if you can. Now, you may want to recite to a witness your client's theory just to kind of put it out again, and then say, now, going with this theory, let's start talking about this. You've heard this 1,000 times. Never ask a question on cross if you don't know the answer. Enough said about that. I've been there too many times. Trust me. Re-examination, and I say re-examination because we are looking at the theme. To get you a theme of your case across, probably best to leave re-examination on theme alone. It's tough enough to re-examine a witness or bring in re-examination witnesses. I figure if the judge hadn't got the theme by that time, sure, he's never going to get it. A non-suit hardly ever succeeds. I've never succeeded. Judge usually says, well, okay, I'll reserve that to the end of the trial. Terrific. But what you do in an application for lawsuits, you say, look, there's nothing here. Absolutely nothing. Here's my theory, the defense theory, for instance. Absolutely nothing. Plaintiff hasn't done a thing. Judge starts thinking, yeah, hasn't done a thing. I'm not going to knock it off, but I'm going to see what the defense comes up with, and if they don't bite the bullet, it's gone. It only brings your theme back again into the judge's mind. Meeting of judges in chambers during the trial, some of them never, zero. Every day for some of the other judges. You spend more time in their chambers than you do out in the courtroom. I always like to think about playing the judges in chambers as interviewing a difficult witness, because you're in there, you're talking about things, and all of a sudden, if you ask the right questions, you're going to get whether the judge likes your theme or not. Maybe you are. Some of the difficulty of that is you may get them to blurt out, I hate your theme, and I hate you, and I hate your client. So that doesn't do you too much good. But these meetings, you can get your theme back across. You can then see if there's any resonance. If the judge is amenable or is going to go the other way. There is an opportunity sometimes if she or he signals they don't like that theory, then you start going back to change the theory. You go back on another tack. The argument. We're now through the case, and I haven't bothered to get into reply. Theory's the same. Let's get to the argument. How do you keep the theory and the issues before the judge in an argument which you're preparing? What I do, and this is only my view of things, if you can, unless you have absolutely no time or no budget, I usually prepare a written outline of the argument, just rough written outline, before the outset of the trial. And you put down on that rough outline what you're supposed to prove. And you put the witnesses beside it. And then you also put the defense witnesses down, just kind of in a rough block. And then as the days go by, the end of each day you go back and you fill it in and say, okay, witness number one, what did he or she prove for us? Okay, put that in, rough evidence of that. Time of the day. Because if judges are still writing, well, they're writing in their computers, but they're writing, they usually put down the time of the day the evidence is given. And if you can roll this back in argument, you will remember in such and such a time somebody gave the evidence. That may be of assistance. Now, here you got this kind of rough draft being created every night as you go along. And the object of the exercise, if you can do it, is to have a written argument ready, by great coincidence, of course, for your final argument. And in many cases, it's impossible because you're compressed with time. But if you keep this thing up all the time, all of a sudden, here you are, standing up, making your closing argument, and you have a written argument. It's not called for in the rules or anything else. You've got a written argument. And the way you set up your outline is in a form of reasons for judgment. In a form of reasons for judgment. And when you're giving the oral presentation, you might say, if the judge has the computer up there, I got a little disc of my outline, would it help? I've never had anybody say, no, it won't help. Now, the other lawyer, if they're good, they got the same thing. If they're not so good, they're saying, well, I'd like to put in written argument myself. Even if the judge says you can do it later on, you got the edge. You got it rolling. You got it in front of them. Now, again, it's money and time. I'm talking about larger cases, a lot of money involved. You don't do that if you're in small claims court, of course. You just wing it. But in order to keep your theme in front of the judge at all times, then the judge goes away, probably looks at it, says, ooh, look at this. I'm going to be a hero here. I don't have to spend 2 months writing reasons for judgment. I just got them on my disc. I'm going to plagiarize. Maybe this is where I wanted to go. Now, isn't this super? Well, I'll change a few things here and there and the rest of it. But boy, I'm going to look good because I'm going to have reasons for judgment that are bulletproof, hopefully, in the Court of Appeal, because look at all this stuff about credibility of witnesses in here. Ooh, yeah, it's terrific stuff. So I'll just go home and play tennis and play with a dog and push a button, and it's all done on Monday. The self-represented opponent. I just want to talk about that in the theme of things. Over 50% of the new cases coming into court are or have self-represented parties. As a matter of fact, the last stuff I read was 10,000 represented incoming last year and 16,000 not represented. So you're going to run across your opponent who is self-represented. You think, terrific. Boy, I'm just going to steamroll over that one. You get your theme across, terrific. And then the judge says to the unrepresented party, can I help you out? And it's got so bad that if you look at page 10, I've given you the website of the judge's directive as to how to proceed for unrepresented litigants. Pages and pages of helping these folks out. You better read it. You better get on the old website, and it's right here. If you get an unrepresented person, the judge, first of all, is going to say, well, what's the theory of your defense, or your plaintiff's case? Oh, God, I don't know. He said, well, come over here and we'll figure it out, you and me, you see. First thing you know, you're over here and those two are there, and it's the judge's theory. He's just come up with this theory. It's not the lawyer's theory, it's his theory. It's her theory. How are you going to dislodge that one? Well, if you see it coming, what you do is you move into the middle and help the unrepresented person. Get the judge out of the way. You get in there and say, I can help. Isn't this terrific? And you put the theory in such a way that you blunt it. It isn't all that bad. And it isn't the judge's idea. Dress your witness to fit the theory. Ever so many trial lawyers just forget this. Justice isn't blind. Justice has very acute eyesight. And I left an example. If your client's theory is impecuniosity because of enormous losses by the defendant, created by the defendant, don't have him walk into court in a Brioni suit with a gold Rolex on. Don't do it. Ruins your theme. Don't have him drive up in his Rolls Royce. Some of you may even remember the great Ian Outerbridge, who's still the great Ian Outerbridge. I had a trial with him in Welland. Welland, that's not Toronto, that's Welland. On the other side, he drove up one morning in a stretch limousine, big black one. He got out, his clients got out, the witnesses got out. I was watching out the window, the court clerk was watching out the window, and so was the judge. He didn't have a chance. Not a chance. Dressed to fit your theory. Now, I'm at the end, and I said that I would leave you with a quotation, which is on the last 2 pages. And we've talked about the theory, we've talked about all these things today. But the key to this whole litigation business is hard work. It's grueling hard work and it's really intense concentration. And I love this piece out of the Civil Action. It's on the last page. Being at trial is like being submerged in deep water for weeks at a time. The world above becomes a faint echo. War, scandal, and natural disaster may occur, but none of it seems to matter. The details of the case occupy every waking hour, and usually intrude into dreams as well. Existence becomes Spartan. When you finally come to the surface to breathe normally again, the world seems altered in fundamental ways. Win or lose, you set about rediscovering pleasures only dimly remembered. Colors seem brighter, food tastes better, the weather is of compelling interest. And that's what happens to the litigation lawyers. Thanks very much.
I want to thank Mr. Bristow for those remarks, which were, as expected, very, very helpful. I want to thank everyone today who has stuck it out to the end. And perhaps just before closing, I'd like specifically to thank the people at the Law Society, Kathy Castaldo, Andrea Camazul, and of course Paul Truster, head of CLE. Their work has been very, very helpful and made this program possible. So once again, thank you very much.